presidential challenge is a very expensive thing. Just look at the bill which IABC put up, and they were not able to get it. Yet they had relied on the production of that voters register to be able to prove a point. So that clearly becomes a challenge. There is also the issue which my brother has mentioned here on the issue of how widespread was their reach in terms of gathering evidence. But you see, that will only do in as far as they are claiming irregularities and illegalities. For me, the crux of this petition ought to be on nomination. And James has got it right, that if what he's defining is that under Article 140, a fresh election means a fresh election. Fresh nominations, fresh gazettements, fresh payment of nomination fees, then that's it. Then Mao has nailed it. It will then mean that the election petition succeeds purely on that.
Interesting. Mambula, your take on the same, on the conduct of the lawyers who are representing the petitioners?
I think with tremendous respect, I need to explain to the public that in most cases, it is not the lawyers that make a case, it is the case that they have. If a petitioner has a case, they have a case. And I want to state it from the very outset that I didn't think that the case the petitioners had this time around was strong. I would want to wait to see what the Supreme Court decides.
Just a moment, which ones?
Both cases were extremely weak, and I don't even think...
Sorry, Wakili, you've just validated Harun Mao's position when you say that the election had to be fresh.
I'm going to explain. I'm going to explain. I've told you that, you know, the IABC has not been operating under extremely clear and forthright circumstances. Remember that the IABC, at the point at which the election of 8th August has been nullified, is now operating under an environment in which they have a court decision from the Supreme Court that says what a fresh presidential election is supposed to be, okay? And it is on that basis that I think the chairman of the IABC made an interpretation and determined that it is these two candidates that were going to be candidates in this particular election and not others, okay? No, so you cannot fault them. I don't agree entirely on his reading of that particular decision, because as I said earlier, I would have expected that he would have included Ekuru Okot if the reading of paragraphs 290 to 294 of the decision of 2013 is anything to go by. However, he chooses to read that particular section of that particular decision in such a stringent and self-defeating manner as to leave out Ekuru Okot, who would have been validly a candidate because he contested the presidential election result in the Supreme Court. Now, having said that, with the clarification that came from Justice Motivos, now we are operating in a totally different environment. Because Motivos is now saying a fresh presidential election is just that, a fresh presidential election, which, of course, should go through all the processes of a fresh presidential election. This would mean, in my view, that he has upstaged the position that was obtaining at the point at which the nullification of the presidential election on 8th August actually happened. But the judge notes something extremely important, that look, within the time span that we are left with, we cannot be able to go through the entire process of a presidential election. We cannot get nominations done because there's not going to be time. So what I need to put out clearly is this. At the point at which Chebukati made the decision to have President Uhuru Kenyatta and Raila Odinga as the only candidates in that election, in the first instance, that was wrong. Because he should have included Ekuru Okot if his reading of the 2013 presidential election petition was actually correct. Now, thereafter, the stage is completely different because the High Court has now given us a clearer interpretation, I think, which is the much more correct interpretation of what a fresh presidential election
should be. Your reaction to that?
Betty, I think, okay, my brother seemed to go round and round, but he has finally driven the point. I think he took a bit long to make the point. He's right when he says that Chebukati selectively applied the Mutunga decision. I call it Mutunga decision. Because the Mutunga decision had said, as James has said, that suppose The word was supposed. They had not been invited specifically to determine that matter. And in law, there is a difference between a supposition. That's why we call it an obiter dicta. So in the first place, a man of Chebukati's legal standing ought to have understood that he cannot go by an obiter decision. However, even when he chose to go by it, he selectively chose what to apply and what not to apply.
Right.
And James is right when he says that if he chose to apply that Article 290, 291, paragraph of that decision, 290, 291, he then ought to have allowed a Ekuro on the ballot. That he claims to have relied on that decision and not allowed a Ekuro on the ballot paper brings a lot of trouble.
All right.
For me, what we are staring at now is becoming very clear. In fact, before I came into this studio, I was not as clear as I'm getting now with the benefit of my brother's interpretation and knowing his philosophical orientation. I'm now settling the position that, look, it will either fall or stand on the basis of whether nominations ought to have been done. Justice Motivos has said they ought to have been done. The only reason why he could not order for them is because there was no time.
There was no time.
And therefore, what the Supreme Court has to decide, the fact that it was not done in the beginning, is it ground enough to nullify the election?
All right.
On the issue of nominations alone.
On that alone.
Yes.
What about the other argument about who should have been part of this, the 290 constituencies, 27 of them not being able to participate?
Allow me to speak on that because my brother has already talked about it.
Yeah.
Look, for me, I thought that was a weak argument. They should not have approached that. Because, yes, Article 138, 1 and 2 say it shall be in all the 290 constituencies. There is no doubt. That is the law, that they ought to have conducted elections in the 290 constituencies. That's a fact. However, there is also a provision that allows IABC to postpone elections if there is a deterioration of peace in those regions. It's on the basis of that that IABC postponed. I do not think they have said they'll never hold again.
Absolutely.
They postponed. So even on
but
that...
will it really matter if, the president is sworn in? What will it really matter?
Now we come to the second limb,
right.
that postponement, you ought not to proceed and announce the results unless, having done your arithmetic, if you take in totality the result, and in totality the number of registered voters who would have voted, in this case 1.7 million, if the arithmetic shows that this number would not alter the final tally, then the IBC is at liberty to go ahead and pronounce. So the participation eventually of the 1.7 then becomes really for the purposes of satisfying the fact that they also have participated in an election.
Yeah, but and it also goes back to the rights of the 1.7 million people. They also have a right to actually participate, in an election. So was that curtailed? It
wasn't curtailed, but now it will be a question of interpretation, Betty, because if the Katiba says all 290 must participate, granted. But remember, the Katiba is the ground norm, is the final law. But there are election laws, and within those election laws, IBC is given that leeway that where there is a breakdown of law and order in a certain section, there's lack of peace, they are allowed to postpone. The question that the Supreme Court therefore has to decide is whether the mere fact that they did not participate, regardless of whether their participation will alter the final result or not, whether that's ground enough to nullify the election. In my view, it's not, because the IABC have acted within the regulations by postponing those elections. So for me, I did not see a very strong ground on the side of the petitioners hinging on that. And you could see that it gave the respondents' lawyers a field day. They were gleeful in the way they were responding and taking pride in answering, because the answers were there. So for me, that was not a strong ground.
All right.
Others could have been. The ones for irregularities and illegalities, again, they were not very strong, because these guys didn't have the evidence the way NASA had last time. And the reason is lack of resources.
Interesting.